those interested, we will do one more round, and the way we're going to do it is we'll have Senator Hagerty, Senator Kennedy, Senator Bozeman, if he wants to stay, and then I will ask my round of questions last and close out the hearing. Senator Hagerty.
Thank you. I'm going to come back to the exchange, Chairman Gensler, that you just had with Senator Durbin. I think it raises an interesting question. It may seem like a broken record, but this is a serious concern of mine. You were describing the circumstances around FTX in its ability to do many things that I think have upset most regulators. It should, the Wild West manner in which they are performing. But I think there's a root issue here. What jurisdictions did FTX choose to domicile itself in?
They had legal entities here in the U.S. They had legal entities overseas. And this is, I think you've hit.
They were in Hong Kong and Bahamas.
Yeah.
That's where their operations were located. The presence here in the United States was minimal, and I think that was intentional.
But they were offering and selling securities to Americans here in the U.S. You could access through websites, and this is the case for a number of these other crypto exchanges as well. They're trying to paper it and layer to make it harder for agencies, both of our agencies, to bring be the cop on the beat. But American investors are accessing them here in the U.S. and under our authority.
That's a grave concern. I just think that the important thing here is that FTX chose to avoid the U.S. market because we don't have certainty here. We don't have regulatory clarity here that would allow these exchanges to come and operate clearly. And as I mentioned in our first discussion, it's a matter of resource allocation, in my view, at the SEC, in allocating resources to put in place a clear and constructive framework for the ecosystem to exist here, to have the resources necessary to do what you described with Senator Durbin, I think would be very big help.
I appreciate what you're saying, but I'm with all respect, going to differ with you. They did not avoid U.S. jurisdiction. I mean, Sam Bankman-Fried's in jail right now, so they didn't avoid U.S. They might have been trying to.
But they harmed U.S.
And
investors.
they did in other crypto exchanges, I believe, are putting at risk Americans. But it's not about just jurisdiction.
But had they been subject to a set of laws and enforcement provisions right here, I think we would have been on top of it much sooner.
They are currently subject to Congress's laws written over 90 years called the Securities Laws, Commodity Exchange Act laws. I'm not going to leave you out, Russ. They are subject to those laws as it relates to crypto security tokens, which, again, without prejudging anyone, I think the vast majority of these are. They're subject to the laws right now, and they're not giving the proper disclosure to your constituents, and the crypto intermediaries are improperly commingling. And we're in court right now pursuing those, and I believe Americans would be better protected. So it's not about, there's nothing about crypto that's inconsistent with the securities laws.
It's the exchanges, and exchanges can't get through the process here because it's become so difficult. It's been made so difficult for crypto exchanges to flourish here, to register here, and to operate. And I'm encouraging
with all respect, that's because they are choosing to try to not comply with U.S. law that so well protects our capital markets. And I would go a little further. We have taken up and written some rules in this area where we think it was appropriate, and talked about the application, whether it's in custody, whether it's in what's called dealers, and when are you a dealer, and so forth. And so we have, in certain circumstances, done that. But in the main, whether it's stored on an accounting ledger called blockchain technology or stored on a notepad, doesn't matter. It's the economics that matter. Is the investing public investing, anticipating profits based on the efforts of others?
What actually does matter is having clarity here in this marketplace. And that does not exist. I can tell you from talking to many market participants, we don't have adequate clarity, and they can't get answers out of the SEC. So again, I'm going to finish this line of questioning and move to something else. But this is something I want to encourage you to focus on. This industry needs to have a proper ecosystem here in America so that we're not shoving it offshore.
If I can say, breaking the law and not liking the law are different than lack of clarity. And with all respect, I think that's what we have a lot in this field.
And we also have a lot of uncertainty and a lot of lack of clarity coming out of the SEC in terms of how these applications are being evaluated. There's a lot of mystery around it. It need not be that way. To come back to another point that Senator Kennedy raised regarding the Fifth Circuit ruling, it raises a question in my mind, is how you balance the risk at the SEC of losing in court versus the allocation of resources that it takes to undertake these rulemakings that I think you probably know are going to be subject to the type of scrutiny and the type of resistance because of the controversy that they raise.
It's on my mind on a very real basis, sir, and has been for my whole 3 years in the job. But I really do think it's such a privilege to serve, and the important thing we do is we look out for 330 million Americans. And in this field, this ever-growing field, $30 trillion of assets under management, more than the whole U.S. banking system, what we believe, and I still believe, that to have greater transparency so that once a quarter investors know their fees, performance, and your arrangements with others, that will help promote greater competition and efficiency, lower the costs.
We're talking about very sophisticated investors with respect to the private funds rule, very sophisticated players in the marketplace, and plenty of competition is noted by how many thousands of funds exist there. Last question I'd like to ask you, and this gets to a concern I think we have for many of the agencies here in Washington, and that is the effort to get people to come back to their office. And in April of last year, the OMB issued a directive to get 50% of the staff back into their offices. And I think the OMB and the White House expect this to occur. And I'm interested in how the commission is thinking about compliance with this rule. Where are you? And to let you just wrap it up, are there real estate implications for this that we need to be considering?
All very good questions. When I was honored to take over the commission, we were a mandatory remote, and we then, Chair Clayton had done that because of COVID. We then entered into negotiations with the bargaining unit, the union, and went to impasse. There's a federal impasse panel, and as a result of that, we have an arrangement through 2026, so it was entered into in 2023, that staff have to come in 2 days a pay period. You can think of it on average 1 day a week. That was the result of the impasse, and that runs through the end of 26. In terms of real estate, we have been shedding real estate. We shedded one of the buildings here in DC. We had 3 buildings. Saves about $14 million a year. We've shed a space in New York. I think we're going through something in Chicago right now. And we also just announced last week that we would be closing the real estate in our Salt Lake City office as well.
Got it. Thank you. Thanks, Mr. Chair.
Thank you, Senator Hagerty. Senator Kennedy. No, go ahead. I'm going to wrap it up. I'm going to wrap it up at the end.